Hi everybody, and welcome to our second 2022 symposium of the Wisconsin Association of Scholars. I'm Benjamin Whitcomb, the president of the Wisconsin Association of Scholars, and it's my delight and privilege to be able to introduce our two speakers today. The first of whom is Professor Ryan Owens. Briefly about Owens, he holds a JD and PhD and is professor of political science and affiliate faculty in the University of Wisconsin Law School and is an honorary fellow in the Institute for Legal Studies. Owens studies law and courts and American political institutions. His work analyzes the United States Supreme Court, the United States Court of Appeals, legal institutions, and judicial behavior. Between 2008 and 2011, Owens was assistant professor of government at Harvard, and he earned his PhD at Washington University in St. Louis. Prior to graduate school, Owens practiced law. Please help welcome him.
Nice job. Great. Well, welcome everybody. Thank you for having me here. I appreciate it. I'm glad to be here. And for everybody who's watching on Zoom, welcome. I hope your connections are working smoothly. So I am going to talk a little bit today about intellectual diversity in higher education. It's a topic of interest to me. It's a topic that's been in the news lately. Of course, we all, I presume, saw the recent firing of a Princeton professor, which I think were reasons basically founded on his political beliefs. They were unpopular. We've seen a tremendous lurch to the left in recent years, and what I'd like to point out is that today higher education suffers from an intellectual monopoly. I'm going to talk about the data on that intellectual monopoly and tell you that it's bad for students, bad for education, and ultimately it's bad for the state of Wisconsin. I'll conclude with a couple of solutions that I think we might want to pursue as we move forward. So universities today have become pretty much completely dominated by the intellectual and ideological left. Recent study by Professor John Shields showed that in 1969, about a quarter of academia was filled with Republicans or conservatives, those who self-identified. So the number was probably a little bit larger than that back then, but 25% identified as such. No longer, of course, is that the case. In their recent book, Passing on the Right, Professor Shields and Josh Dunn highlight some of the data on faculty today, and it really is alarming. So they took a look at social sciences first, and they found that only 7 to 9% of faculty in the social sciences identified as conservative or Republicans. At the same time, about 18% of those people identified as Marxists. So Republicans are even more underrepresented on college campuses today than Marxists are, which is quite a shocking statistic. Economics was pretty much the only field within the social sciences that showed any sort of a ray of light for Republicans or conservatives. But if you look at some of the other ones, sociology, and like we're about 3%. That's just not good. Okay. Humanities are just about the same there. We're looking at about 4 or 5%. That actually surprised me to the extent that it was that high to begin with. But this is basically going on everywhere, all across the entire discipline. The academy is significantly to the left of the American public. Fine. What are the consequences of this, though? From my perspective, more important than the numbers of liberals, progressives in the discipline is basically how they use their power. And I think that's where we need to be somewhat concerned if we are a believer in higher education, as I am, and I suspect that everybody who's listening to this is as well. I think many times in these discussions about conservatives and liberals in academia, what gets lost is the fact that we're all trying to improve it. It's not that conservatives just want to come in and take a hammer to higher education. Maybe some do, but I think at base, most of them want to reform it, protect it, because we understand, at least in Wisconsin, the University of Wisconsin system drives billions of dollars in our economy every single year. We can't let that go to waste and get co-opted by folks. I think if we want to provide an example, maybe of one of the problems that happened, I think we just need to look at the day after President Trump was elected. In 2016, campuses across the country wound up giving students the day off so that they can mentally cope with that loss. I don't know what it says about either our students or the institutions of higher learning that they feel they need to give students a day off to cope with an election loss. That is not something that's good. We hear on a daily basis about how our democracy is in disarray. It seems to me this is certainly a symptom of it, if one will. It's been a profound lurch to the left, and I think that's a problem for us. Take a look at some examples of the University of California system. Recently there, the university provided some professors with examples of microaggressions that they were to avoid. I'm assuming everybody here has probably heard the term microaggression before. If you haven't, it's called the everyday slights, indignities, put-downs, and insults that people of color, women, LGBT populations, or others who are marginalized experience in their day-to-day interactions with people. So a backhanded compliment, something like that would be a microaggression. Okay, we used to call that just not being polite, but fine, we'll have to call it a microaggression these days. But among the microaggressions that the University of California system told professors they could not engage in was to say the following, that America is the land of opportunity. You were not allowed to say America is the land of opportunity for fear of triggering someone. When I look at you, I don't see color. I'm colorblind. That's a no-no as well. I believe the most qualified person should get the job. Better not say that, because that'll land you in hot water as well. Okay? All of this, of course, is what UC Berkeley in particular said was referencing the myth of meritocracy, which was, simply put, a tool to further white supremacy. Now, if this sounds crazy, it's because in part it is. And we all know the consequences of groupthink. Groupthink leads to bad behavior. It leads to unchecked behavior, and that is a problem. So many of the universities, of course, will not be outdone by the UC system. They have required students, faculty, administrators to go through anti-racist training, which on its root, at its root sounds good. Anti-racism, that sounds like a good thing. Equity, that sounds like a good thing. But these are not things that are pursuant to the American ideal. Equity is not about bringing everybody up together. If you get into the weeds in equity, what you find out is that's a term that is used to try to discriminate against some to benefit others. Equity is not equality, it's something very different. Anti-racism is not about being not a racist. It's about forcing people to apologize for the color of their skin, something they had no choice in the matter of. And this is Martin Luther King turned upside down. And regrettably, this is what universities are pushing these days. And I think it's a tremendous problem, both for our students, but of course for the future of higher education. So a couple of other things have gone unchecked because of this lurch to the left. And that is, I think, illegal hiring practices. This is something that, with any luck, will receive some legal attention in the future. Places like the University of Wisconsin system, certainly UW-Madison, is engaged in hiring practices which are clearly illegal. Rather than going through the standard hiring practice where you get approval from a dean to open up a line and you engage in a nationwide search, you bring candidates in from across the country and hear them talk and you evaluate them. Instead, what universities are doing right now is using back channels, sort of a good old boys club from days past where you find out, hey, do you have a student of color who might be on the job market? And if so, tell them to apply. But you know who can't apply? White males. They are definitionally excluded from this program, and the University of Wisconsin system is pursuing it without any concern whatsoever about the effects that it might have. Over the last 10 or so years, I think, they've hired 25 people through this process, and they may be great faculty members. I'm not saying that they're not. But what is quite clear is there has not been a single male, white male, who has been hired on those lines, and I would tell you it's because they're not even able to be part of that process. It's illegal, it's unconstitutional, and it's immoral. We know that we're not supposed to treat people on the basis of their skin color, but when you have a university system that is engaged in groupthink, like most are these days, questions aren't being asked about the propriety of some of the actions undertaken. So we need to overcome that. I think more importantly, at least for our students, is just the fact that this intellectual monopoly seems to be impeding their academic success and their success in the job market down the road. You don't have to take my word for it. You can take the word of that arch-conservative Mike Bloomberg from New York, who in 2014 said that a university, and he was talking about Harvard, he said a university cannot be great so long as its faculty is politically homogenous. And I think that's absolutely true. Students who are exposed to an ideology that is almost exclusively left-wing, they're going to be ill-prepared to function in a society where the vast majority of people are to the right of Alexandria Ocasio-Cortez. But you wouldn't think that to look at college campuses today. Regrettably, there was a study and some interviews done by some folks in the workforce. And one chief human resource officer said that graduates now, they lack creative problem solving. College graduates today lack creative problem solving. 60% of businesses surveyed said that today's college grads lack critical thinking skills. 44% said they don't write well, and 39% said they couldn't speak publicly. I think many of us see this same thing in our schools today. And of course, this isn't a problem necessarily that universities own, the public school system does as well. But the fact of the matter is we are getting worse and worse and worse at educating our students and our future workers in the marketplace at the same time that college costs more and more and more. It's a system that's destined to fail, and there are, as of now, no repercussions for what has gone on. And I think that's a problem. So one more thing to note before I talk about some potential solutions to this problem. We've been told over the last few years that we need to follow the science, okay? And we can always put the science in quotation marks, follow the science. I think most of the time that's a good philosophy. We should be trying to advance ourselves as much as we possibly can. The problem, however, is that when you have people in gatekeeping positions who aren't engaged in, I would say, a fair respect for the science itself becomes skewed. And the data then on which we rely moving forward is no longer scientifically valid, but more ideologically pursued than anything else. So one recent study found that 25% of psychologists surveyed would be at least somewhat inclined to reject an article if they knew it was written by a conservative professor. One quarter of the discipline in psychology said that they would reject a study if they knew the person was conservative. Another study examined the behavior of employment practices. They took two studies, okay, the authors of this particular study, they took two studies. They used identical methodologies. And they examined, one was reverse discrimination against whites, and the other was discrimination against minorities in the workforce. All the data, everything was exactly the same, but for who the intended victim was in the study, okay? Without question, the study that pursued reverse discrimination was harassed and attacked far more by the outside reviewers in the study that looked at discrimination in the workplace against minorities. And some of the reviewers were quite clear that they didn't like the study because they thought it might set affirmative action policies back decades. That's a policy discussion that has no business in higher education whatsoever, and yet it proves the point that when you have a tipping point reached and a groupthink that exists, we can't do much about this any longer. So what's going to happen? Higher education is going to get more and more politicized. Budgets will get cut. We're going to hear screaming about academic freedom. And from where I sit right now, attacks on academic freedom are occurring every single day. Whether it's DEI supervisors trying to look at syllabi to make sure that you have enough women or minorities on the syllabus, or whether you have campus representatives sitting in on classes to make sure that nothing askew is going on. That already has violated academic freedom, and yet we don't hear any cry about that. It's a problem. So what do we need to do? Well, I think first off, we've got to have more people coming in from the private sector into administrative roles in higher education. There is nothing particularly unique about academia that would prevent somebody who values higher education and who has a good business sense, for example, from examining what's going on as a dean or as a provost. There is no reason not to do that, and yet we act as though it's some sort of special job that needs expertise. It is a difficult job. It is an important job, but it is not one that requires a monopoly from within, particularly when we have people right now who are thinking all the same way. We have to mix it up. We know the value of diversity. We've heard the value of diversity. It's time that in these positions, universities put their money where their mouths are, and we actually start to get some different kinds of employment and perhaps intellectual diversity there. At the same time, I think we've got to do far more to enhance civic awareness among our graduates. I have recommended somewhat ironically, but truthfully, that everybody should have to pass a test about the First Amendment once they graduate from college. We have far too many students who fall back on totalitarian beliefs about what is or is not free speech, what is so-called hate speech. I did a survey not long ago, and the statistics among some of the students at UW-Madison were alarming. Well over 60% thought it would be okay for the government to punish so-called hate speech. But when you give someone a definition of hate speech, they can't ever really pin it down on what it means. So it's just speech with which you disagree. We need to have our students come out of colleges with more understanding of First Amendment principles, not just what the law is. That's important, but why the law is the way it is, why we should value free speech. Okay. Finally, I think universities have to award more credit for students who are going to do on-the-job training. There is no reason, frankly, for us to have a 4-year undergraduate program, whereas people sit in classes for 4 years. Frankly, law schools shouldn't be 3 years in a classroom either. Okay, students should be able to keep more of the money that they have rather than having to go 4 years. But if we force them to go out, or allow them, I should say, to go out in their final year to get on-the-job training, give them class credit for it, it's going to benefit everybody. Employers will have the capacity to sort of test drive students as potential employees. Those students will understand what it means to be an effective employee in the marketplace, and they'll get out into the real world without thinking that everything is just the way it is on college campuses. It seems to be a scenario, I think, where everybody could benefit. But that's not going to happen if we continue to have staff, leadership, executive leadership that all sort of think the same way about the world and about the way universities operate. We need to open this up a little bit. Higher education shouldn't be a monastery. It shouldn't be a place that people don't think they belong or that they can't touch. It needs to be opened up, and I think once it is opened up, people will understand better what we do, and we will understand a little bit better by ourselves how we can improve, because ultimately, higher education is the best way forward, I think, to climb that social ladder. It's the best way forward for everybody in society today to have advancements. But we've got to be more careful with how we treat it today. And so hopefully with those 3 things, I think we can pursue an agenda that makes more sense. We've got a problem. We've got to do something about it. And hopefully this is a good starting. So I'll stop talking there. Thank you very much for listening.
Thank you. Thank you, Professor Owens. Sobering stuff, but I always very much appreciate having solutions put forward as well. And next we have Justice Daniel Kelly, who was appointed to the Wisconsin Supreme Court by Governor Scott Walker in 2016 to fill the vacancy by the retirement of Justice Prosser, Jr. Before joining the court, Kelly had 19 years experience as a practice attorney in Wisconsin and represented clients in cases before the Wisconsin Supreme Court and the U.S. Supreme Court. Kelly spent most of his private practice career at one of the largest and oldest law firms in Wisconsin. Subsequently, he served as vice president and general counsel for a philanthropic foundation, and then practiced law at a firm he owned and founded in Waukesha. Kelly is a member of the Board of Advisors and past president of the Milwaukee Lawyers chapter of the Federalist Society. He serves on the Carroll University President's Advisory Council and is a former member of the Wisconsin Advisory Committee of the U.S. Commission on Civil Rights. He was the author of a landmark Wisconsin Supreme Court decision in 2018, John McAdams versus Marquette University, that was a strong endorsement of academic freedom in higher education. Please help me welcome Justice Daniel.
Well, good afternoon, everyone. It's good to see all of you. It's good to go after Professor Owens, whom I've known for many years, but I was somewhat alarmed to learn that part of his body of work was to study judicial behavior. I just have to know, am I under scrutiny right now?
You are, pal.
Okay. That's going to be tough. All right, I'm going to set a timer here. Doesn't mean I'm going to stop talking when it goes off. Just curious how much over I'm going to go. It was Constitution Day just 2 weeks ago. And so I thought it might be worthwhile to remember that 235 years ago, Benjamin Franklin walked out of Independence Hall after having signed one of the what would become one of the most famous documents in all human history, the new Constitution. The Constitutional Convention had just finished up its work and was preparing to introduce to a waiting and watching country a brand new and novel form of government. And as he exited Independence Hall, a woman approached him and said, "Mr. Franklin, what have you given us, monarchy or a republic?" And with a twinkle in his eye, Mr. Franklin said, "A republic, if you can keep it. If you can keep it. If you can keep it." See, Benjamin Franklin was not referring to the group of people who had just signed the document. He wasn't referring to the people who would hold office under this brand new Constitution. He was referring to the woman standing in front of them, and by extension, all of her fellow Americans. If you can keep it, if you can keep it, it's not a guarantee. One of the things I've learned over many years is that you don't keep what you don't treasure. And you can't treasure what you don't understand. So I thought perhaps we spend a little bit of time reminding ourselves of why we treasure our Constitution so dearly as we do. Now, there are parts of the Constitution that everybody knows. I refer to them as the rock star provisions, right? Everybody knows the First Amendment. Protects our right to freedom of religion and speech, press, and the right to peacefully assemble, petition the government for redress of grievances. The Second Amendment, we all know, the right to keep and bear arms. And who could forget the Third Amendment? Probably the favorite of everyone, right? Third Amendment, hey, ring any bells? Third Amendment? Yeah, it's the guarantee the government cannot quarter soldiers in private homes in times of peace. Okay, so that's not one of the rock star provisions of the Constitution. But these provisions that we all know and occupy our mind space when we think about the Constitution, they did not exist when Benjamin Franklin answered that question when we posed to him. That came 4 years later. This is 1787. There's no Bill of Rights yet. It won't be for 4 years. And yet, Benjamin Franklin and all the people he worked with in the Constitutional Convention understood themselves to have done something truly novel and revolutionary in the document that they put together. So what was it? What was the thing that captured their imagination? What was the thing that they believed they were going to offer a waiting and watching country that would preserve their liberties and yet enable a government to govern? What was the central piece? The central piece, something they borrowed from Montesquieu, was the idea of the separation of powers. Right? We all know we have 3 branches in our government: the legislative, executive, and judicial. That was their new offer to the world, was to instantiate what Montesquieu had written about. I oftentimes talk with folks about separation of powers and how their understanding of it works, and I've often found that the understanding is, let's call it incomplete. And so I've thought of a way that I talk to them about it that I think it's perhaps a little easier for them to remember and understand. So I think there's a really strong correlation between each of the branches of government and a spot on a timeline. Right? On a timeline, we've got future, we've got present, we've got the past. And each one of those branches correlates strongly to one of those spots on the timeline. We oftentimes talk about the 3 branches as being co-equal, right? You've heard that? That's a relatively new concept. Now, they are co-equal in dignity, right? So when the Constitution assigns some measure of authority to one branch, the other branches don't get to touch it. That's for that branch to do and none of the others. They are co-equal in dignity. But the founders did not understand them to be co-equal in importance or in function. And so they looked at the legislative branch, and that was to be the lead agency in the entire governmental structure. That's one of the reasons why it is the more populous of the branches. So their responsibility correlates strongly to the future, that spot on the timeline. They've got a tough job. They have to peer into the uncertain future and gather all of their experience and their wisdom and their intelligence and try to figure out what laws they can pass that will contribute to human flourishing, that will govern our actions from today into the future. That's a hard job. The executive takes for himself matters of the present. So there's strong correlation between executive authority and the president. His job is really, and the job of the judiciary as well, is really derivative of what the legislature does. The executive's job is to take the work of the legislature and apply it today in a way that will contribute to human flourishing. And he is to do that today and every tomorrow as it becomes today. His job is the present to apply that law. Now that leaves one branch and one spot left on the timeline. So we got the judicial branch, and by the way, it brings up the caboose spot in our constitutional structure for a reason, right? The United States Constitution, they go 1, 2, and 3. Article 1 is the legislature, 2 is the executive, bringing up the rear, 3, the judiciary. Here in Wisconsin, Article 4 is the legislature, 5 is the executive, 6 deals with some administrative matters, and then, almost as an afterthought, here comes the judiciary in Article 7. There's a reason for that. And the reason is this: the work of the court is done in a museum of sorts. And just like in a real museum, when the judge puts on his robe and walks into that metaphorical museum, he finds artifacts. And he finds 2 kinds. The first type is, well, they're the facts of the case that occurred that he is adjudicating. So that's one type of artifact. The other type of artifact is the law. See, the legislature is always going about its business, and it never stops making new law. And so the law today is not the same as the law was yesterday, or the day before that, or maybe 3 years prior to that. And a lot of the cases that the court deals with address facts that occurred many years ago. And so the responsibility of the jurist is in going into that museum to look at those artifacts, the facts that occurred, and then the law as it existed when those facts occurred. Not the law today, not the law that we might want it to be tomorrow, but the law that actually existed at the time the controversy arose. And then the jurist's responsibility is simply to take that body of law, apply it to the facts in the case, come to the resolution. And here's one of the most important parts of the judge's job. It's to stop at that point. See, we don't want the judiciary being original, creative, innovative. None of these descriptors apply to a court. We aren't interested in what a court thinks the law ought to be, or how it can be done more effectively or efficiently. None of that comes into the role of the court, and it can't for structural reasons. Because if a court innovates, if a court makes law, it then destroys the very concept of the rule of law, right? Rule of law is pretty simple. It is that we adopt a law, and that governs the actions from that point forward. We have to know what's expected of us. And if we know what's expected of us, then we can choose to conform our actions to what the law requires. That's the rule of law. But what happens when a jurist goes into the museum, but he brings stuff with him? And he walks in and he says, well, I see the law as it existed back then, but I think that's out of date. I don't think it was framed especially well. I don't think it's efficient and efficacious, and I've got a better idea on how to do this. Now, jurists will never say it quite that boldly. They come up with nice-sounding phrases like a living constitution. Perhaps you've heard of that. A living constitution is one that exists not on paper and preserved in the National Archives. It is something that exists in a jurist's head. And he trots it out when he doesn't like what the actual document says. He says, why, that was adopted 235 years ago. Went into effect 233 years ago. How could such a document possibly control today's affairs? So we'll update it. I'll do a tweak here and a change there. I'll ignore that provision. I'll find something that's not really in the text, and I'll say that that controls the outcome of this case. And when you do that, you rob the citizenry of the rule of law, because that person in that case, when those facts occurred, when that person made his decisions on how to comply with the law, that's not what the law said back then. And when you read that law back into the museum, you rob that person of the protection of the rule of law. So the way I look at showed up in Prince, apparently a few weeks ago, and someone said that I had views of the law that were radical and outside the mainstream. Love that. My view of the law is that the courts should follow it. That's radical and outside the mainstream. Not sure what to tell you. You won't keep what you don't treasure. And you can't treasure what you don't understand. I was reading an article just a few weeks ago. It was in The Hill. The article was on a poll that was recently taken, and the question being polled was this: should the president be able to remove a jurist whose decisions he believes are at odds with the national interest? The results of that poll were these. 35% said yes. The president should be able to remove a jurist whose opinions he believes are adverse to the national interest. 22% said, no, I don't know, maybe. So that's 57% of the people, and now, that's 57% of the respondents. Now the people who do polling and all the black arts that are involved in that, they tell me that you can reliably infer that the population matches that sample. And if that's true, that tells me that 57% of our fellow Americans don't really want the Constitution. They want to be able to conflate those different branches. They want to make the courts subservient to the executive branch. It's not the way it was structured. Now, I'm willing to bet that if you asked these 57% of the respondents, would you like to dispose of the Constitution? The vast majority of them would probably say no. We love the Constitution, they would say. And yet, they had told the pollster they would be completely okay, 35%, or ambivalent, about removing what the framers believed was the central novelty in the government that they had created. The very reason for drafting the Constitution. Okay, we find with disposing of that. You see, you won't keep what you don't treasure, and you can't treasure what you don't understand. And I think those vast majority of those 57% would say, I want to keep the Constitution. They don't understand the Constitution. And so they couldn't treasure it. And so they're willing to not keep it. When I think about Benjamin Franklin's answer, Republic, if you can keep it, I oftentimes think of the Shakespeare play, Henry V. You might remember that King Henry had asserted a claim to the crown of France. And he sent his uncle, the Duke of Exeter, down to France to present his claim to the court, the royal court. And the Duke of Exeter went in and stood before the king and presented King Henry's demands. And the king said, well, what if I don't accede? The Duke of Exeter said, bloody constraint. Because if you hide the crown of France, even in your hearts, there will King Henry reign for us. See, King Henry was not interested in the golden bauble that the King of France wore on his hat. He was after the real crown, the one that the people of France hide in their hearts, the one that really gives the King of France his authority, his power. That's what he was after. Similarly here, if we are going to keep our form of government, we have to hide that in our lives. So we have a pressure to that. It's good news, not saying it is for us, isn't it? Yes. Okay. Just like the French hid the crown in their hearts, and that maintained the king's authority, we'll maintain our constitutional authority if we hide the Constitution in our hearts. But that does require that we understand it. If we understand it, I think we will treasure it. And if we treasure it, then we'll keep it. And then the woman's answer, Benjamin Franklin's answer to the woman's question 235 years ago, we can pass that down to the generations behind us for the next 235 years. So thank you so much for allowing me to come out and spend this time with you. God bless you all.
Thanks so much. And now, Professor Owens and Justice Kelly will form a two-person panel to field questions that we have. Thank you both.
All right.
I've got a question for Justice Kelly.
Yes, sir.
Justice Kelly, the judiciary, you say, might be subservient in the scenario you said, but some people think the judiciary has exceeded its power and is the most powerful branch. And we know, I think the comment was Alexander Bickel who talked about the least powerful, the least dangerous branch was the judiciary, and many people now think it's the most dangerous branch. Could you just comment on that?
Yes, and then by tomorrow at 4 o'clock or so, I'll wrap up my remarks. That is, so the observation that the court would be the least dangerous branch would be true only so long as it maintains its proper place, right? Because it is not given any innovative powers. It is there simply to say what the Constitution says and what the statutes say. You know, Chief Justice John Marshall said that it is the job of the judiciary to say what the law is, to say what it is. Now, that's not the godlike power to speak things into existence, not that kind of stuff. He was referring to, well, you look at the Constitution and the statutes, and then you say what they say. It required a measure of fidelity and commitment to the words of those documents. It required a measure of humility. You don't go into the judiciary if you want to change the world. That's not its role, never has been, and properly speaking, it never will be. Now you step outside of that role, now it goes immediately from being the least dangerous branch to the most dangerous branch. There's a great example in point just recently down in North Carolina. Evenly divided Supreme Court along ideological grounds. The legislature had passed some proposed constitutional amendments and went to the public for ratification. They ratified it, and then those constitutional amendments were challenged in court. And the basis for the challenge was, well, you know, the legislature was malapportioned, and so none of their work should have any validity. Well, not all of this work should have no validity. Just the really important stuff like constitutional amendments. And the Supreme Court of North Carolina said, we strike down these constitutional amendments. Not all the statutory work that this malapportioned legislature had done, just the constitutional amendments. Now, the problem with that, of course, is that the court receives all of its authority, 100% of its authority from the state constitution and nowhere else. And yet in that decision, it set itself above the Constitution because that's the only way it can decide what that document may or may not contain. And so it went from being the least dangerous branch, just saying what the legislature says and what the Constitution says, and it put itself above it and said, we will be the ultimate guardians of, well, everything in North Carolina, and we will superintend what goes into the Constitution, what doesn't. And what that does is completely remove self-governance from the people of North Carolina. How are they supposed to change the way their government functions if the Supreme Court is sitting separate and apart from that document and telling the people of North Carolina what they can and cannot put in the document? It's supposed to empower that court, but it's limited authority. And so stepping outside of that boundary does make it no longer the least dangerous branch. I completely agree.
I would say in follow-up to that too, we talked about Hamilton, we talked about Marshall. Very rarely do I ever see anyone assign or talk about the anti-federalist papers on this. And it's crazy. You go back and you read Brutus 12, that's written by Robert Yates, who was a patriot from New York. He went to the Constitutional Convention, didn't like what he saw, didn't sign it. He went back and he opposed ratification. And in Anti-Federalist 12, Brutus 12, he says you can't trust the federal courts because they have an incentive to read federal law broadly. Because the more broadly we read federal law, the more authority Congress has. The more authority Congress has, the more authority the Supreme Court takes on. And eventually they will swallow up the states. I think on this example here, Hamilton in number 78 was absolutely wrong. And Brutus was probably more right than Hamilton was on this. One point you made too about Justice Kelly, you mentioned something about 57% of respondents in this poll being okay with the president usurping his authority as it relates to courts. In my own research, I've just done a poll. We're looking at things like term limits for justices at the federal level, but also things that people look for in federal judicial candidates. And it turns out that if you give respondents an option of what kind of a judge do you want, liberal, moderate, conservative, Republican, black, white, young, whatever, you give them all these attributes out there, roughly a third of the entire population of the country looks most closely at the ideology of the justice, not their judicial philosophy, but their ideology. That is not good for the future of our democratic republic.
Yes.
I have a question that both of you can answer. So the question broadly is, how can you reform an institution which has a purpose, but those that control it have decided to use it for political expediency to achieve their preferred political goals? So in the case of the university, how can any institutional reforms you make have any impact if a critical mass of professors are already intent on acting in a certain way? And as it concerns the courts, I'm interested in your comments on, many states elect judges as compared to the federal system. So could you comment on the relative merits of that institutional approach?
You want to go first?
Sure. So I assume that we're all familiar with the prisoner's dilemma, right? Which is, you get two people and both pursuing their short-term interests leads to decisions that for them are rational, but in the long run wind up becoming less good, if you will, for society. So how do you get out of the prisoner's dilemma? How do you avoid making bad short-term decisions when we all know that in the long run we'd be better off making different decisions? There are lots of different things that you can do. But I'm reminded somewhat ironically of Thomas Hobbes, right? The state of nature. What do you have to do to get out of the state of nature that's nasty, brutish, and short? You have to give power to an outside source that will come in and control and change the way people think. Now, I think higher education, we don't need a Leviathan, okay? But we do need to open ourselves out to some more external transparency and or I don't say control, but bring outside people in, okay? The only way you're gonna get yourself out of this is to open up and let other people say, here's what you're doing wrong. Ironically, if you read all kinds of the literature on behavioral economics, cognitive psychology, and you go to some of these training seminars now about how people can open up to admit their privileges and their biases. Well, what's one of the things they say? Open up your company, open up your system so that we can come in, observe, and help you train. It seems to me universities aren't doing that right now. So I think that's the necessary first step with that right there.
Yeah, on the courts, those are the two major ways of populating the court, either through appointment or through election. Here in Wisconsin, of course, we elect our judges all the way up from circuit court all the way up to Supreme Court. And I think there are strengths and weaknesses in both measures. One of the things that we often look to in the way that we populate our courts is to try to squeeze out politics, right? And make sure that the person that is going to be sitting on the bench is going to do the job of a jurist instead of the job of a politician. And that's just terribly tricky to get that. Now, in some ways, I think an appointive system does a better job of squeezing out the politics. You have a much narrower group of people to whom you must attract to your cause. And it's all done pretty much out in the open, right? There's senatorial hearings and all of that. And even in the nomination process at the federal level, there are oftentimes nominating commissions that forward certain names along to the president for the nomination. So it's above board. It's out in public. There's not a lot of opportunity to do typical campaigning, and by that I mean, what we see oftentimes in the legislative branch is that candidates will tap one way or the other depending on the audience they're talking to. And so it becomes very politicized. And so it's possible for that to seep into an elected judiciary as well. Candidates have to go out, and their responsibility is to attract enough support to win an election. And the temptation is, well, I'll tell this group this, and I'll tell that group that, and the things that I'm going to tell them will be political as opposed to judicial, right? Because there is that third of the population who wants to hear about their ideology, their political ideology. Where are you going to stand on these different issues? And that is death to the judicial project. Once you get to the court, your responsibility, because we all have political views, every single jurist has political views, but your responsibility is to set them aside and do the work in the court. Now, you have to have a methodology so that you can actually do that, because if you just leave it up to your gut instincts, you'll start bringing in your politics. And so as I have campaigned in the past, I've been told that I don't do much with stump speech. And that's true. That's partly by design, it's partly because I just don't like stump speeches. So what I do when I campaign is I talk to people about their authority and how they lend it through the Constitution to the different branches of government, and what that means for the job of the judiciary. And then I explain how a jurist who is committed to that limited, humble role is able to do that job in squeezing out the politics and just saying what the law says. And the short version of it is that you start with the law as the premises of the case you're going to decide. That's your responsibility. Then you use rigorous logic to move from those premises down to the conclusion. And then you check your work. You go back and you make sure that there's an unbroken line of logic between the premises and the conclusion. And you do it in such a way that the public can see it and is accessible. And you do it in language that they can understand, so you stay away from the legal jargon, right? Because in a lot of ways, that opinion is your report card to your bosses on what you've done with their authority. And so they should be able to look at the opinion and be able to track the line of logic from the premises down to the conclusion. And if it's unbroken, then they can be confident that the conclusion is what's required by the law. Now, if there's a break in the logic in there anywhere, that's where the jurist's personal views will start to seep in. And that's when you should start getting worried about the job of the jurist. But we have an elected judiciary here, and there are some benefits to it as well. So the detriments are that it kind of brings in the risk of politicization of courts. One of the benefits, though, is recognizing that the court exercises borrowed authority. They borrow from the people of Wisconsin. That makes the people of Wisconsin their bosses. That means that every 10 years, if you're on the Supreme Court, 6 years if you're on the Court of Appeals or Circuit Court, you go back to your bosses and you say, this is what I have done with the authority that you loaned to me. Do you approve? And if they approve, they can send you back. And if they disapprove, they say, we're going to get somebody else. Right? So I think that's a significant benefit to an elected judiciary because it maintains that connection between the jurists and their bosses. And I think that's one of the areas where if you lose that connection, that opens the door for the court going its own way rather than following. All right. What else?
Comment and then a question for both of you. Justice Kelly, I think you said that you don't become a judge to save the world.
Yeah.
And I agree with that. Unfortunately, there is a generation of lawyers, judges, who would answer that question in a very, very different way, including a number of justices on the Supreme Court. I assume that if you ask that question to Justices Sotomayor or Kagan, they would say, I did become a lawyer or a judge to save the world. And I wonder if there is some way we can change the judicial system, change the way we even train our lawyers so that they understand that if you want to change the world, go into politics, go into activism, but if you want to be a lawyer, you're not necessarily, you're going to uphold institutions that already exist, uphold our system, but you're not going to change the world. And in today's society, so many people want to change the world for various reasons, sometimes personal egotism. And that will draw them into the judicial field, legal profession, maybe for the wrong reasons. Yeah. So in other words, if you want drama, if you want excitement, if you want to be on the front lines, do something else. And it's hard to say. It's hard to tell people that. That's my comment. Now, my question for both of you is, what's been on my mind for a long, long time is the case that has worked its way up to the Supreme Court. It's about to be argued and decided, and that's the Harvard and North Carolina fair admissions cases, which I'm sure you're familiar with. And I'm wondering if both of you can give me a prediction, a crystal ball, if you could, as to how you think that decision is going to go. Because I've been thinking about it for a very, very long time.
Yeah.
And worrying about it for a very, very long time.
Sure. I don't think there's any way the court takes that case without knowing that it's going to change the status quo.
And the status quo that both on the district court level and the Court of Appeals have upheld the admissions policies of those two schools.
The reason they took this case, both of these cases I should say, is because they are going to change the law. Now I think the question, and by that I mean they're going to say that the admissions programs which currently take race into consideration are somehow wrong, unconstitutional for some reason or another. The question then becomes, how far do they go with changing the doctrine? I think most people sort of presumed up until the end of last term that the court would maybe tinker with it a little bit and not go after it full-throated. But I think others have suggested now, given the Dobbs decision, this is not a court that's going to go incrementally. I'm inclined to think that this court will do some serious change to the constitutional sort of status quo on this. If you read the tea leaves on this, Chief Justice Roberts even, was perceived to be a sort of a squishy conservative vote. If you read his case, or his decision out of the Seattle case about 10 years ago, what was his famous line, right?
The way to stop talking about race is to stop talking about race.
The way to stop discriminating on the basis of race
yeah.
is to stop discriminating on the basis of race. And he got pilloried by Justice Sotomayor for making that comment. But I think that's where this court is headed. I would not be surprised to see a very strong decision on it.
I think that's certainly a possibility. There's also a possibility that they might have taken the case on a dare. So what I mean by that is it only takes 4 votes to bring a case to the United States Supreme Court. Right? So if you do our math, that's less than a majority. And so it's possible, and courts sometimes do take up cases where they're not going to change the legal regime that they're addressing, and they do it because they think, well, maybe the 4 might say, well, I think we can get one of the others convinced to go along this direction, and you never know. So I take your point on Chief Justice, and that was uncharacteristic of him to say something so categorical. So I think one of the countervailing impulses here is going to be the Chief Justice's institutionalism. So we saw that in the ACA case, where he was consciously thinking about how the court would be perceived if they struck down the Affordable Care Act, and that led him to just exceptional gymnastics. I mean, if that was an Olympic event, he would have just nailed the 10.
Acrobatics.
Yes.
Yeah.
And then in the Dobbs decision as well, he did not join overturning vote. And I think largely because he's concerned about how the court would be viewed. And so I think that might play into this. If this does get changed, I mean, there is, you probably played Jenga, when you were a kid. This is going to be like Jenga on steroids. You pull that out, there's going to be not only that's going to fall, there's going to be across the legal spectrum, there are going to be repercussions if that happens. And I think that the Chief Justice and Kavanaugh, that's going to get them to think, perhaps maybe we don't want to do this at all, or maybe we need to be just really careful and just dip our toe into the water and see what happens. Always come back in a future case and address it further. So, I mean, it's possible. Dobbs was earth-shattering. And so they certainly have the capacity to make major change in our jurisprudence in a single step. But I think perhaps the reaction to Dobbs might get the Chief Justice and Kavanaugh thinking, we were a little aggressive there. Maybe we should just settle down for a bit. So, I don't know. All that to say, I have no idea.
What worries me is the possibility of a plurality decision coming out of this. I think this area of the law is just a mess to begin with. The court is inevitably going to run into Voting Rights Act challenges smacking up against the 14th Amendment. We've seen that for the last 10 years. That's coming up. I think this could speak to that. But you get Justice O'Connor in her opinion 23 years ago saying it's going to be 25 years and we're done with this. I mean, you would talk about judicial activism. Where does that nonsense come from? So the court needs to speak clearly on this. And I think conservatives could lose Roberts, and fine, we saw that with Dobbs. You lose Roberts, it doesn't matter, you still have it. If you lose Kavanaugh too, and then you have a split court, plurality decision, that's a mess. So my sense is if you can't get a strong majority on something with this, the court might maybe dismiss the case as improvidently granted. If they just can't do it, maybe they hold it over for another term, maybe they dig it. I don't know, but I think they've got to have some clarity on this law.
Because so much of the issues in higher education that you were talking about and that we know exist, they will continue unless there is some clarity and I think some change here.
I see we're just about out of time, but maybe I can get you the last question, Benjamin.
Oh, definitely.
Okay, balance of power. I think Justice Kelly was going through a little bit of that. So Congress can pass a law, the president can veto it. Congress can overturn the president by 2/3 vote of each house. I think it was Justice Jackson who commented something to the effect that we're right because we're final, or words to that effect.
Yeah.
So let's go back to something you said about Justice Marshall, or you commented on him. Marbury, judicial review started it all. Pretty shaky reasoning, I think, in Marbury versus Madison. He did stretch everything to get to his point, but it was a political point to save the country, because that was the last bastion of federalism and nationalism at the time, right? You get Jefferson and the Republicans, which are not Democrats, stood for everything the opposite. So Marshall had to do everything he could do. And shortly after that decision, one of his colleagues was impeached. And all the justices attended. As I understand it, Justice Marshall wrote a private letter to, I believe it was probably the President pro tem of the Senate or somebody like that, suggesting that maybe a compromise rather than these impeachment proceedings. Because he figured if he gets impeached, we're all gone the next week anyway. I think he suggested in a letter that they have the same procedure for judicial opinions, that the Senate and the House could overturn a judicial opinion by a 2/3 vote. What do you think of that idea?
Yeah, I think that would be a significant problem. I think that would essentially eliminate the Constitution. So you look at the actual case of Marbury, and you're right. The way he applied the principles is a little shaky. But the practice of what we come to call judicial review was indisputably correct. Now, when I address this, I reject the term judicial review, that that's a thing. It's not really a thing. So a jurist has the responsibility, as I mentioned, of following the law. Right? So the Constitution is legally binding on the work of the court, as are the statutes, to the extent they are compliant with the Constitution. So this treating the Constitution as a legally binding document requires that a court look at the statute and say, can I comply with the statute and the Constitution at the same time? And the whole point of what he's writing about in Marbury was what happens when you can't. If I'm deciding this case and the statute says I have to decide one way, and the Constitution says I have to decide it a different way, what do I do? Well, the answer has to be you follow the Constitution. And in doing so, you are implicitly saying, and by the way, that statute, to the extent it required a different resolution, that's not compliant with the Constitution. So so I think that that aspect is required by the nature of the court and by the nature of the Constitution. Because if it was otherwise, if instead of saying, well, I'm going to follow the Constitution, not otherwise, if you did otherwise, now the Constitution becomes a dead letter. Because if a subservient document can overcome the document that created the possibility for that subservient document to exist, then the top-level document goes away. Similarly, if you have the Senate and the House, and whatever proportions you want to stipulate, be able to say, well, we're going to reverse you, Court of Appeals or Supreme Court. Well, then it does demote the Supreme Court to the Court of Appeals, and it makes the Supreme Court the Senate and the House. The problem here is there has to be a stopping point, and it brings up a question that my wife frequently asks me. She's never satisfied with the answer because it's a frustrating answer. So she says, what happens when a constitutional officer does not comply with his constitutional obligations when he steps outside the role that the the Constitution signs, and who's watching him, right? So essentially, that was the same thing that Chief Justice was talking about. Okay, so if you think that we got it wrong, well then you do something about it. But it just backs the problem up one step. All right, fine, you do that. Well then who's watching the Senate and the House? Making sure they get it right. And the answer is always the same. We are. We the people. Right? The Constitution preamble starts, if you've seen a facsimile or the original, first three words, much more fancy calligraphy, much larger letters than the rest of the document. We the people. We the people. So all of the authority to create and maintain governments belongs to we the people. And we simply loan some of that authority to people in government. And as in any really important loan, we write down the terms to make sure that we don't forget what they are. And more importantly, make sure that they don't forget what they are. And when we get done writing out that document, we call it a constitution. That's the thing that moderates between the people and their chosen servants. And it does make them servants. Right? So their responsibility is to look to we the people as their bosses. And our responsibility is to look at them as servants. And when they step out of line, it is our responsibility to take care of business and either push them back into line or remove them. There is no magic procedure within the government by which you can get the government to always pay attention to the rules. That belongs to us. And it's one of the reasons why it's so important that we carefully choose who we elect to our offices. Because they're, in relation to the court, they're then going to decide who sits on our courts. But ultimately, that authority all comes back to us. We have to be careful with the franchise. We have to be serious and sober-minded citizens, taking the responsibility seriously, that all of that authority is ours, and we need to be careful about who we allow to use that authority in our name and our behalf. So not a terribly fulfilling or satisfying answer, I don't think, but I think it has to be that.
Well, would you like to add anything as well?
No, I think the one thing I would point out is the problem with allowing the House and the Senate to have the last word, if you will, for this stuff is, I think it flies in the face of the entire reason for adopting the Constitution in the first place. And that was to create institutional checks on what many of the framers called mobocracy. We don't want to make it too easy for a faction to gain control of the majority of government and do what it can to trample on the rights of the minority. Obviously, they weren't talking about racial minorities the way we think about them today, property holders, people with different points of views. And judicial review itself is a protection of the rule of law. It's a protection of minority interests under the law. And if we gut that and allow the House and the Senate to come in, we're going to have real problems. People tend to think, oh, we open it up, everybody's going to treat one another nicely. No, they won't. They will not. That has not been the history of mankind. And so those protections are there for a reason. Do you think the Second Amendment would exist today if it was opened up for a vote? I suspect not in many places. And many of us treasure the Second Amendment. I think that right would be gone pretty quickly. So I think we got to make sure that we're protecting minority interests as well. Judicial review does that.
Well, thank you both.